now in session.
Good morning. You may be seated. We are here today on our case number 1CA TX15 Arizona Cattle Growers Association versus Yavapai County et al. Counsel, you both know that you're allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to do so, you're in charge of keeping track of your own time. The clock on the podium reflects the total amount you have remaining, including what you may have decided to reserve. But we have this in case something happens. We have read the briefs. We've studied the record, and we've also discussed the case in our conference this week. We record these proceedings, I should have said before, we record these proceedings, so when you approach the podium and each time for the appellant, we'd be grateful if you would recite your name and the name of your clients into the microphone for our recording. So with that, Mr. Mooney, you may proceed.
Thank you, Your Honor. Good morning. May it please the Court. For the record, my name is Paul Mooney. I'm here on behalf of the plaintiffs and appellants who are too numerous to mention, or I would try to list them all. A number of them are here this morning, having made the drive down from Yavapai County to be here. I'll try and reserve about 7 minutes, which is more than I normally would because we have two arguments coming, I believe, so I may need a little more time than I normally would. Following a 4-day trial to the tax court in March of 2014, the tax court issued a ruling largely granting my clients the relief they requested in their complaint. However, due to a pretrial ruling, which was affirmed again post-trial, there is an issue that we've raised on appeal relating to whether or not my clients pled a proper claim for mandamus relief that should not have been dismissed pretrial and that in fact should have justified the relief that we asked for and in fact did, and should have correspondingly resulted in an award of mandatory attorney's fees under ARS Section 12-2030. The second issue we've raised on appeal relates to evidence that was undisputed at trial. There was simply no contrary evidence presented by the defendants at all. No expert testified for the defense, no witness testified for the defense regarding the exclusion, which is what the tax court did, of federal and state grazing leases in the calculation of the statutory full cash value in this case under ARS 42-13101. We believe both of those constitute grounds for reversal on those issues and only those discrete issues. I will focus briefly on the mandamus issue and try to address any questions on that because I think it's pretty straightforward. It is a pure legal issue in my view. It is a ruling that resulted from, I believe, a misapprehension on the judge's part regarding what mandamus requires. In effect, the judge believed that mandamus is a forward-looking remedy only and that therefore, since the cat was out of the bag, so to speak, it was too late to put it back in, and therefore he ultimately denied the claim. In denying the claim, he noted that he could not say that there had been an abuse of discretion by the Yavapai County assessor in this case. Of course, following the trial, he changed his tune. He obviously heard the evidence and concluded, based on the same evidence that was before him on the cross motions, really were in summary judgment. It was an order to show cause on our part and a cross motion for summary judgment filed by the defendant, Yavapai County. He concluded that there hadn't been an abuse at that point. Obviously, following the hearing of all the evidence, he changed his mind and 3 times in his ruling indicated that the assessor had in fact abused her discretion. As a result of that, since there was not a final ruling, we asked him to reconsider the pretrial ruling as part of his ruling on the question of whether or not my clients were entitled to an award of their legal fees for this 3 years of litigation in which they spent nearly $300,000 dealing with the government's litigation strategy in this case. And at the end of the day, the government had no defense. The evidence was undisputed at trial that the assessor never did any study of the lease rates in Yavapai County that should be used under 42-13-101. Not should be used, have to be used under 13-101.
Does a party in your client's position seeking mandamus, though, need to need to demonstrate that it lacks an adequate remedy at law?
Yes, we did lack an adequate remedy at law in this case, although interestingly, the judge did not deny it on that ground, and that argument was never made by the defendants. Leaving that aside, it is a predicate, you're right, under 12-.
But your clients largely got the relief that they wanted.
No, they didn't.
Well,
They got reductions in their value ultimately, but what they never got, and they never got until the tax court did the assessor's job, was they never got a study done to determine what is the average annual net cash rental for grazing property in Yavapai County. It was that duty that was imposed exclusively on the assessor in Yavapai County that was not discharged.
Although ultimately, as you said, the tax court did what the assessor should have done and figured it out.
The tax
Looked
court-
at your expert's report.
The tax court had to do that, but what's interesting about this case, if the tax court had simply held the order to show cause hearing when it was brought, which was before the taxes were ever levied, this issue would have been resolved early on, and we wouldn't have had to go through a protracted trial and protracted litigation over all of these different parcels of real estate in which the county started raising arguments they had never raised before, like, well, does it even qualify as agricultural property? I mean, these are properties they determined were all qualifying agricultural properties, and in the course of the litigation, they started challenging things like that. This is not a typical valuation appeal, because this is a case where the assessor had determined that the relevant area was the county as a whole, and the relevant class was all natural grazing property. And the assessor simply arbitrarily increased that by over 300% with the stroke of a pen. That once that issue was determined, every one of the 508 parcels that are involved in this case, the value was fixed. There was no dispute about the capitalization rate that was determined by DOR, and there was no dispute about how many acres we're talking about for each parcel. Those were known facts. What was the unknown here was what the assessor was bound by law to do, and which she failed to do. So with due respect, I think the remedy we sought at the outset of the litigation on a verified complaint was a proper remedy, because we had no other adequate remedy at law to compel her to follow the law. She had simply refused. And so it was a proper mandamus action, and she did in fact abuse her discretion, because she never did the study, even though she had data from which she could have done a study, and she relied on something that the judge concluded properly was never intended for that use, and was in fact lacking in foundation that it was unsupportable as a basis on which to determine those. So in practical effect, we believe we had no adequate remedy at law. If the question is, did I ultimately get some relief from what the judge did? Certainly. We pled the complaint in 4 separate claims, one of which was for valuation relief as an appeal, one of which was for declaratory relief, one of which was for mandamus, and one of which was claiming that taxes were illegal because they had been set without doing the required study. We proved all of those claims, including the mandamus claim, and so therefore we believed that we were entitled to the relief we requested at the outset of the litigation. And the fact that the relief is being ordered retroactively now is no different than what this court has upheld in repeated property tax cases involving mandamus relief. The Garcia case, the Telco case, all of those cases, Hormel, all those cases involved retrospective relief after the fact, but they involved relief that was mandated by law.
But they're not valuation cases.
They were. E.C.
Well,
Garcia was a valuation case involving whether property qualified as agricultural property. It's the only case I've ever been before this court on for 3 oral arguments. We actually had argument and had a reconsideration and had another argument and had a third argument before the decision came down. But it was a valuation case involving agricultural property in Pima County. And this court said mandamus relief was appropriate in that case to order the assessor to do what the law required. This case is no different. And with due respect, I think the evidence is so overwhelming that the issue here isn't Stagecoach Trails or any of the cases they've cited, because it isn't a question of exercising discretion. The assessor simply didn't do her job. She doesn't have the right not to do her job, not to do her duty. It isn't a question of how she did her job. If she'd done something, then we could talk about that, but she didn't here. And that's why we believe the mandamus relief is appropriate. Let me turn, though, to the federal and state grazing lease issue, which I think is where the parties have spent most of their time briefing. Unlike the mandamus claim, this isn't purely a legal issue, but it is in part a legal issue. I think it's a mixed question of law and fact. And it's both because I believe the court misconstrued the relevant statute. 4213-101 is the statute which applies to determine full cash value of agricultural property. Nobody disputes that. The law in Arizona defines full cash value as the value determined as prescribed by statute. This statute then sets forth a method. That method has two components. Cap rate's not in dispute. The only other element is the numerator of the calculation, which is the average annual net cash rental of similar agricultural property in the vicinity of the subject. And it says that you look at typical arm's length rental agreements. There's been a lot of debate in the briefs about what arm's length means. Arm's length means very clearly what it says, that the parties are not related. And if there was any doubt about that, all we have to do is look at the statutes which talk about the information that the taxpayer has to provide. 13102, which is the immediately following statute, which clearly relates to this because it says the statement that's required in this section shall be used by the assessor for the valuation process under section 13101. So clearly 13102 is in pari materia with 101. 13102 requires each lease of agricultural land or agreement to rent agricultural land for a period of more than 90 days shall be abstracted in a written statement in a form approved by the Department of Revenue, and we attach some of those forms. They show a whole column for government leases that have to be reported, interestingly enough. And it isn't just leases, it's any agreement to rent properties. That deals with the whole issue of licenses and permits. But then subsection 5 of A in that statute says the conditions of the lease, and then this language, including the relationship, if any, of the parties. Clearly, the legislature understood when they enacted this statute that what they didn't want was they didn't want family members leasing land to each other on favorable terms and having that be the basis. The notion that the United States government, the Bureau of Land Management, the Forest Service, the Department of Agriculture, the State Land Department, that they're somehow in the pocket of my clients is absurd.
I don't think the argument is that the government's in the pocket of your clients. I think, or vice versa. I think the argument is that the Department of Agriculture manual, maybe it's a DOR manual, gives a valuable and appropriate gloss on the statute and tells us how to interpret that.
It does, but it doesn't give a gloss that is consistent with what Judge Fink did. There is nowhere in that manual does it say that you can wholesale exclude federal and state grazing leases.
I'm not sure that we know that's what Judge Fink did, though.
Well, what we do, because he repeatedly said limited use, 3 times in his
limited use of the government leases.
Limited use of federal and state leases. And in fact, in his ruling, of course, he excluded all of them. We know he did because the value he set was higher than the private land-only leases that Mr. Rolston used.
Although from Mr. Ralston's report, though, you can discern the rent charged under the subleases of government land,
but not the discrete rent that's paid. In other words, to do that, you have to know the carrying capacity. And what Mr. Rolston did was what the statutes authorize and in fact require. If you look at 12-151 at SEC, those are the statutes that define what agricultural property is in Arizona. 152 subsection A3 says this: the property of agricultural property consists of non-contiguous parcels. If it consists of non-contiguous parcels, the non-contiguous parcels must be managed and operated on a unitary basis, and each parcel must make a functional contribution to the agricultural use of the property as a whole. What Rolston testified to repeatedly was, yeah, I looked at ranches. I looked at ranches as a whole, which consisted in every instance, and in fact he said in every instance in the state, it consisted of combinations of deeded land, leased deeded land, state land, BLM land. Now, by the way, it doesn't include any Forest Service leases because those cannot be sublet by law. And the state land leases and the BLM leases can be, but they're subject to a 25% surcharge, and a new rental rate has to be computed based on that surcharge. So that they contemplate that those can be sublet. But the point here is that he looked at ranches as an economic unit. His study was the only evidence presented at trial that looked at ranches that were qualifying agricultural properties.
But I'm not sure why Judge Fink could not have obtained from your expert report, could have used that data to calculate the lease for government subleased land, subleased government land.
If he had done that and he had shown us what he did and how he did it, and if he had told us what the alleged flaws were in Mr. Rolston's report, we could ascertain that. But his findings of fact don't do that. In fact...
Make findings of fact.
Yes, he did. He made detailed findings of fact. Under advisement ruling, findings of fact that went on...
I've read that several times.
Those were his findings of fact and his conclusions of law, and he adopted those because the parties requested them under Rule 52 pre-trial. And he was required to do that. And the point I make with respect to the findings of fact and the conclusions of law is those are entitled to deference, but they're not absolute. They have to be based on evidence. If this case had gone to a jury, as it was originally scheduled to do, the jury would have been instructed, you have to decide the case based on the evidence presented in court. Evidence consists of testimony of witnesses and exhibits. That's it. There's no testimony from a witness. There's no exhibits and evidence that establish the number that Judge Fink chose. I respectfully submit that if a jury had rendered the decision he did, it would be subject to an NOV. Because no reasonable juror could have done what Judge Fink did. There's no evidence in the record from which you can do that. Judge Fink may have thought the value was too low that Mr. Rolston computed. He recited what it was in a separate finding in his decision. But he may have thought it was too low. He may have believed it was too low. He may have had the gut feeling that it was wrong or too low. He even surmises that, well, everybody liked it for 25 years or nobody challenged it. That isn't evidence. With all due respect, that's not evidence. That's an instinct. That's a feeling. That's not something that we can affirm when it's contrary to the only evidence in the record. Moreover, plain language of the statute controls. We don't even need to look at the agricultural property manual. It's a guideline. It's not mandatory. It's not a law. It's not a regulation. It wasn't adopted under GERC. It doesn't have any particular standing. It's a guideline. And it doesn't say what Judge Fink says. It says you may need to exclude federal leases, but it says at the same time it says you should consider all leases. It says you may need to make adjustments. What adjustments were made? Nobody made any adjustments here. We know Judge Fink didn't make any adjustments because his number's higher than the private-only number that Mr. Rolston testified to. So he obviously didn't include any. That's a flaw here because over 80% of the land that is leased for grazing in Yavapai County is public land. Did the legislature in 1967 write a statute that they intended that the average would be the average of less than 20% of the land that's used for grazing? With all due respect, that doesn't pass the smell test. That's not an average. If they wanted to say that, they could have said that. They didn't. If that's what the department wants to argue they should say, then the department needs to go to the legislature and ask them to change the law and put in the word private or non-public. They didn't do that. I'm going to save what little remaining time I have for a rebuttal. Thank you.
May it please the Court, Jerry Freese from the Department of Revenue. I plan on spending no more than 10 minutes of the time on my argument and save the remaining time for the county.
What issues will you be addressing?
I will be addressing,
from what the county
Your Honor,
will be addressing?
Solely the lease issues, the federal and BLM and state lease issues, which I addressed in my answering brief. I'd like to address Mr. Mooney's last point that he made, that Judge Fink, there's no basis for what Judge Fink ruled. What Judge Fink did, he clearly stated in his findings, what he did is he accepted Ralston's private grazing number. He rejected the BLM rate, he rejected the state rate, he objected the private number, and then he made a small upward adjustment, as he stated in his ruling. So it's very clear what he did. He did what...
What was the basis of the upward adjustment?
Well, that's in his ruling. He found a couple of small problems with what Ralston did, and he set that forth in his ruling.
And what supports his decision to upwardly adjust?
Well, that's in his ruling, and I don't remember, quite frankly. They were relatively small adjustments. He basically went with the private number, and the upward adjustments were like 5 or 10%, and it's in the ruling. But what he did is he rejected the private, or the BLM rate. He rejected the state rate. He went with the private rate. He did exactly what the department argued and what the county argued he should do. And then he did what any trier of fact would do in, say, a condemnation case, where you have one opinion of value, you have another opinion of value, you have testimony about adjustments that be made, and the trier of fact, whether it be a jury or a judge, says, Instead of finding $5 a square foot or $10 a square foot, we find $7.25, and that's what the judge did. And in this case, it's far easier because the rejections that he did were objective. He objectively rejected the federal rate. He objectively rejected the state rate. That is objective. It is as clear as it can get.
It's clear he didn't value the federal leases at their face value.
Correct.
It's clear well, it's not clear. What he could have done, seems to me, is he could have, under the guidance in the manual, he could have said, well, I need to look at the sublease rents, the subleases of government land. They tell me what the arm's length value of those leases actually were. And it seems to me from the report, you can calculate what some of those subleases were going for, and they were going for far more than
Correct.
70 cents
Correct.
an acre. And so that might have allowed the court to upwardly adjust the private lease number.
That may have been it. I think there was something else, and again, they're identified in the ruling. I can't remember it offhand. The upward adjustment had to do with the fact that the BLM rate, we picked out in our briefing, we picked out one lease, YA11, and it was permitted by the BLM at $1.35 an AUM, and it was sublet at 10. So he rejected the $1.35, and if you're going to do a technical adjustment, what did he do? He adjusted it up to 10. And you don't have to guess about what the adjustments are because it's subleased at $10. So it's kind of a hyper-technical way of saying, what adjustment do you make? Well, we adjusted it to what it conveyed for in an arm's length transaction. But you don't have to go through all that language about the adjustment. You simply look at that transaction, and the transaction suggested $10.
In fact, why are government leases not within the ambit of an arm's length transaction?
Because that's public policy. That's the law. And as Mr. Mooney set forth in his reply brief, the BLM rate is determined by three factors: current grazing rates, beef cattle prices, and the cost of livestock production. And that's...
But how is it not at arm's length? I mean, I don't know if I would go as far as Mr. Mooney, that it only depends on whether there's a relationship or not.
It's not
but there's no connection, it seems, between the government and the person or the entity leasing.
Well, they're not related, but there's far more to an arm's length transaction than whether or not people are related. Even related people, a related party transaction, as their expert testified, can be an arm's length transaction.
Yeah.
So arm's length is just not simply that we're unrelated. Arm's length is two entities, related, unrelated, semi-related, not remotely related, coming together and negotiating and coming to an agreement about the fair value of something.
And what authority do you have that that's the definition?
Pardon me?
What authority do you have that is?
We have
the
numerous
definition?
authorities in our briefing. We have the federal estate tax authority. We have many authorities we've cited in our briefing. That's the measure of an arm's length transaction. That's what their expert testified to. I mean, the testimony is extremely clear. Two entities coming together. And so why is the BLM rate of $1.35 not a market rate, not an arm's length rate? Because it's a flat rate. A market implies that you have variance. In Yavapai County, we know from their appraisal, their rental study, that there's a wide variance between what things rent for based upon the carrying capacity.
But so are you saying that arm's length transaction means the market rate?
It is it is a study of what people in the market for agricultural grazing properties, they come together, they come to an agreement about what some land is worth. Some land is worth more than others. Some land is worth far more than others. And they come to an agreement. And the assessor is obligated to look at all that. Ranchers are obligated to report that data. The assessor is obligated to collect that data and come to a determination of what the rental value is of grazing lands. And that is what, based upon arm's length transactions. And so getting back to the BLM formula, the BLM formula is a formula. It generates a number not just for Yavapai County, not for the state, but for the entire country. It is a fiat number. It is not a market number. Secondarily, under state law, the costs of the livestock production are not to be deducted. Once you come upon a private grazing rate, and that's the first element of the federal formula, is the current private grazing lease rates. And then under the federal formula, you do two other analyses, you do two other deductions. Under state law, you don't do any of that. You don't take the cost of livestock production into account. It's simply what these things rent for. And so the federal BLM permit rate, by definition, cannot apply, is not a state rate. And that's a matter of law, because the BLM rate takes things into account that the state rate doesn't, and it's a matter of statute in the state because the federal rate is not an arm's length rate. It is not negotiated.
So how do you square 42.13.101A, which says that land is used for agricultural purposes shall be valued without any allowance for urban or market influences, and then you're arguing that nevertheless market is implied in the arm's length transaction.
What that language means is that you can't use standard appraisal methods to value these kinds of properties. So normally when you value a grazing property, you go out and look at what do these properties sell for. And I can tell you they sell for a lot more than $10 an acre. They sell for $2,500 or $4,500 or $8,500 an acre or more. What that statute says is you can't look at that market data. You can't look at the urban influences of the fact that qualifying agricultural land, whether in Yavapai County or in Maricopa County, out in Buckeye or whatever, is to be valued at a market rate. The market rate in Buckeye could be $100,000 per acre. But if it's a qualifying ag property, then it's valued under the ag statute. So that language is meant to exclude the standard appraisal method language. Now, under the ag valuation statute, there is a small market component, and that's inherent in the statute. And what it says is, as ag land, what it rents for as qualifying agricultural land in an arm's length transaction, that's how you determine the value. So there is a small market component. The language, Judge, that you read is not applicable because, again, the statute inherently contains a market component, and that is what land rents for.
How long has the DOR manual been in effect? When was that first issued?
A long time. I have no idea. 40 or 50 years would be my guess.
Has the relevant language changed over time?
I'm sure it has. I have no idea. The DOR has been my client for 4 years, so I'm sure it does change intermittently.
What's the process by which that manual is issued, amended, adopted?
I don't think it goes through the typical administrative process. I think it is done. The department is actually authorized by statute to do it. The department is authorized to prescribe guidelines and valuation guidelines by statute, so they have the inherent authority to do that, and they do it, and they change it on occasion. So, if the court has no other questions.
Thank you.
Thank you.
May it please the court, counsel, my name is Roberta Livesay, and I represent Yavapai County and Assessor Pearsall. I see that I don't have very much time left, but, well, actually I do. I have more. I was looking at the wrong screen. I think in talking about the mandamus issue, I'd like to start at the end and work backwards. Look at what the plaintiffs are actually asking for in terms of relief in their briefs. When you go to the last page, they're not asking that the court remand this case back to the Yavapai County assessor to force her to do a study that they claim she has an absolute duty to do, and then publish that because their clients will obtain something from that study that she didn't do back in 2010. That's not what they're asking. They're asking for this court to order that the values be lowered to the number that they say you can extract from the rent compilation, the lease compilations that their expert witness did. They said that's the only evidence in the record, so we don't need a new trial. Just go back and take Mr. Ralston's numbers. Well, how is that relief in the form of mandamus? If they're right, and they're not right, but if they're right that only the assessor can do the analysis, then why should this court give them the relief that they are requesting? The relief they request shows the fallacy in their own argument. They don't want the assessor to do a new study. They want even lower values than they got from the tax court. But let's look at what happened here in this case. We have a brand new assessor. She takes office, looks at the values for grazing property, and sees that they have not been changed in 25 years. And she looks at the statute, and her understanding of the statute is they're supposed to be looked at annually. So for 25 years, the cattle growers didn't complain that nobody was doing a study. But the assessor looked at the statutes and saw that the statutes impose a duty by the use of the word shall on the Department of Revenue to assist county assessors in, amongst other things, doing the valuations required by law. So the brand new assessor goes to the Department of Revenue and says, these haven't been changed in 25 years. I have no context here, no frame of reference. I don't know exactly what I'm supposed to do, how I'm supposed to do this. Would you help me, because that's what you are empowered by law to do? The DOR says, yes, we're empowered by law to do that. We'll gather these leases from all over the state, and we'll do this study for every county in the state. Does the study, gives the results to the Yavapai County assessor. Yavapai County assessor looks, well, first of all, Yavapai County assessor gives about 200 lease abstracts. And I use that term because the statute doesn't require the cattle growers or cattle grazers to submit actual leases. It just says, here, abstract this information and give it to us. DOR testimony was over 100 of those were not useful because they had zero rent. So they couldn't be used for a rent study. And some of them were what the department called junk leases. The department winnowed those down to 26 that were useful for the study. Takes that information that it had come from the assessor, then puts it together, does its analysis, because the guidelines say you have to do it over a 5-year period to smooth out the fluctuations, okay? So the department's the only one who did that. Mr. Ralston didn't do it. He just put some numbers in a report and said, here's the math. And at trial, I objected to that. I said, you didn't do that, so we don't know. It's not really an opinion, it's just math. And the court said, okay, so that's what happened. But the assessor then looked at what she got from the department and said, yeah, it looks like it complies with the law to me. Now we have to get that gross number down to a net number. We take the department's capitalization rate, and we put the values out. And they did go up. They went up. Very surprisingly, any property owner would be shocked to get that. So it's not a surprise that the cattle growers appealed on valuation. So this really always has been a straightforward valuation appeal.
What if, as Mr. Mooney argues, though, what if the trial court had ruled at the beginning, assessor, you didn't do your own study, you need to do your own study, go back and do your own study. I mean, I think that's the argument. That's the argument in favor of the mandamus here. And theoretically, the whole valuation trial could have been avoided.
But, Your Honor, I don't think that would have been the result, because by law, the roll with the values on it has to be completed by December 15th of the year prior to the date of value. So that was done by the time that this case was filed and the order to show cause was submitted. We were already looking at past history. It was a matter of public record, and the court denied motions for summary judgment, said we need to look at the facts because, and this is what I believe that the judge was thinking, when you look at what the statute actually says, the statute that the cattle growers say, this imposes a specific duty on the assessor. She has to do the analysis. It's 42-13101, and this is what it says. It says the average annual net cash rental is determined through an analysis of typical arm's length rental agreements. It doesn't say who has to do it. And the court actually found at the end of everything that it was perfectly fine for the assessor to use the assistance of the Department of Revenue for the purpose of conducting that study. The court just said, I don't like the way the Department of Revenue did its study. Now that we've dug into it, I think that study was flawed. And in this case, that's why in my answering brief, I tried to draw a distinction between an abuse of discretion, because I think if you don't look at it really critically and really analytically, you just see the word discretion and think, oh, the judge at the end of trial said the court abused, the county abused its discretion. But this is why the yes on Prop 200 case is so helpful here. And it's one of 6 cases, I believe, that I mentioned in my answering brief that the cattle growers completely ignored in their reply brief, didn't even deal with it. But yes on Prop 200 drew a distinction between the function of courts and the discretion courts have, and the function of the Attorney General in issuing an Attorney General opinion. And the court in Yes on Prop 200 said, it is because the function of courts is to declare existing law that they abuse their discretion when they make a legal error. Because the function of attorneys general, however, is not to decide what the law is, but merely opine about the law, the same principle does not necessarily apply. So the assessor has specific duties that are set forth in the law. And I know I cited it in my brief, and I think it's 13002. But those duties are to annually identify property, find its full cash value, and put those properties on the rolls. So if the assessor had failed to identify property, failed to find full cash value, or failed to put property on the roll, that would be an abuse of her discretion for which mandamus would apply. But she did all that. She valued these properties. The cattle growers are just saying, we don't like the value she came up with.
Does the available of an adequate remedy preclude mandamus relief here?
Yes, it does. And we briefed that to the tax court. We showed the statutes, and we mentioned it in our briefs that we had done that because we didn't want to rehash all those arguments again. But it does preclude it because, again, in my answering brief, I said there's not one exhibit. There wasn't an offer of proof made. There wasn't a witness who was denied the ability to take the stand that they had called because the special action counts had been dismissed. They couldn't show any harm at trial. Ergo, trial provided them the adequate, plain, speedy remedy that everybody challenging valuation has to them. There's also a statute that says no injunctions shall lie to prevent the collection of taxes. That one doesn't really apply. I tried to stretch that in the tax court to say that it did, but in all candor, it doesn't really apply. But they can't stand before you here and say that they didn't get anything that would have benefited them. They got exactly what they asked for in the sense that they had their expert who did his own compilation of rents and said this is what the number is, and the judge said, yeah, it's close, but not quite. And I can fill the court in on some details that were asked of Mr. Freeze, which is Mr. Ralston admitted at trial that he should not have included a water ranch, for instance, as one of his leases. Well, he did include it, and it was part of the number that he came up with. He also agreed that he shouldn't have included pasturage agreements. Those are private. He did include them, and so it impacted his number. And it's quite possible that when Judge Fink took the findings of fact and conclusions of law that were drafted by the cattle growers and simply repeated them, but tweak the numbers, but that's what he was thinking about. There's evidence in the record to support him making the slight upward adjustments that he did. So the bottom line is the whole mandamus issue, and they waived their declaratory action. They didn't brief that in their opening brief, so they don't get that. They only have to get mandamus, and they can't under stagecoach trails and under Prop 200. It's simply not available. And I talked really fast, and it's at 0, so unless you have any more questions, I'll sit down.
No, thank you.
Thank you.
Thank you. I'm going to have to speed through this fairly quickly, and I apologize for that, but what you just heard, I'll go in reverse order. What you just heard from Ms. Livesay about Ms. Pearsall's and being a new assessor and what happened with the department is simply fiction. There's nothing in the record to support that. It's an absolute story. Second, she asked the question, why? Why did we ask for what we did? We did ask for what we did because somebody has to order the assessor to follow the law. She hasn't followed the law since she started doing this. That's the plain and simple answer. And if somebody doesn't order her to do it, it isn't ever going to happen. And my clients don't have the money to come back every year and challenge arbitrary valuation decisions that are not based on a study that she's required by law to do. That's the answer to the why question. Parenthetically, the last DOR study that was done in '98, they completely ignored because that one would have set the values at $1.50 an acre for the land. That's what Mr. Lapata from the DOR testified, who did both studies. Yavapai wasn't too interested in what DOR had to say back in 1998 when the values were much lower. As for Mr. Freeze, again, fiction. I would invite you to read paragraphs 36 through 50 of the findings of fact. If you want to focus in particular on the only ones that address the alleged flaws, paragraph 44. This is the entirety of 44. The court finds Mr. Rolson's study to have a number of flaws. Doesn't tell us what they are. And in the next paragraph he doesn't. He just says, the court finds Mr. Rolson should not have used public grazing leases in the manner he did. Doesn't tell us what he did that was improper, because in fact the numbers that he adopted were based in part on public grazing leases that were part of the ranches that he analyzed. And he testified about that. There was no dispute about that at trial. Paragraph 46, there were a number of other more minor concerns raised by Yavapai County regarding Mr. Rolson's study, and the court agrees with several of them. Which ones? We don't know, because he didn't tell us. There's nothing in this order that does what Mr. Freeze just said. There's nothing in the order that tells us what the judge found flawed. Simply not there. As for what is arm's length, and you asked several questions about that, Judge Howe, the best answer I ever heard to that question was the one given by Mr. Grosetta, who testified at trial. He's the only rancher who testified at trial. And they were cross-examining him and trying to get him to agree that the leases that he negotiates with the BLM and the Forest Service and the State Land Department aren't at arm's length because they're not negotiated. He doesn't have any input on the price. And his response was, when I go to Safeway to buy a gallon of milk, I pay what they tell me a gallon of milk costs. If I don't like what the price of the gallon of milk is at Safeway, I go to Bash's. Those are market transactions. You don't have any leverage when you go to Safeway, and yet that's an arm's length transaction when you go buy a gallon of milk at Safeway. It's based on a price that's set by the merchant. In this case, the BLM and the Forest Service and the Land Department did exactly the same thing. They set a price based on criteria that are established by law. They don't have any flexibility over it. They have to follow the law. Federal law in the case of BLM and the Forest Service, state law in the case of the State Land Department. They don't have any discretion. And the notion that somehow that's not at arm's length, I think, is simply preposterous. I'm out of time. Thank you.
Thank you to both sides for your argument. We'll take the matter under advisement and issue a decision in due course.